you're going through the in vitro fertilization or surrogacy process, I know it's hard. I know it's expensive. I went through it myself for 4 years. So we do, though, have to consider the estate planning implications because there's really important, very responsible things that you need to take into consideration now. First of all, if you're dealing with a surrogate, it's important that you let them know that you've made accommodation should something happen to you before your children are born, right? Who's going to be their legal guardian if the intended parents aren't around to take over that role? If you're a parent going through the IVF process, you want to make sure you've informed your estate planning attorney, whether it's myself, we cover all of Florida, or if you're in another state, you talk to your own attorney there. You want to make sure you've spoken to them about your frozen genetic material if you have any. And that's because these frozen embryos may not be biologically related to one or both of the intended parents. You want to make sure that the estate planning documents don't specifically exclude children who are not biologically related, because I've seen this happen. I don't know if it's always intentional or not. It's sometimes just generic language that's kind of boilerplate and put in there. So you want to make sure you have that discussion with whoever your estate planning attorney happens to be. This is especially an important issue to bring up if you're a single parent going through the assisted reproductive technology process, same-sex couples, or really anyone using a donor embryo. We also see this as a big issue to address with grandparents who they may have prepared an estate plan years ago that never contemplated IVF or surrogacy issues. So they may have to make amendments to their estate plan as well, so they're not specifically and unintentionally disinheriting their grandchildren. There's also an issue that you need to be aware of known as posthumous conception. Essentially, Florida statutes say that if a couple freezes their embryos and later one of these spouses of the intended parents passes away, the child can only inherit from that deceased parent if they specifically contemplate this in their estate plan, right? And if it's silent, then there could be legal issues down the road, essentially all these unintended consequences. If you have frozen genetic material, you want to also keep in mind this is considered personal property in the state of Florida. You want the fertility clinic's forms because they're all going to make you sign these disposition forms as to what happens with your genetic material, either after you may have leftover genetic material after your children are born, or what happens when parents pass away. You want to make sure that what's in those disposition forms provided to you by the facility match what's in your estate planning documents so they're not conflicting. I'm Jason Neufeld. I'm an estate planning attorney in Florida. If you'd like to schedule a consultation to discuss these issues and also generic estate plan, right after these children are born, you got to think about who's going to be their guardian if, God forbid, something happens to you, who can make healthcare decisions for them if you're temporarily unable to make those decisions for them. There's all these sorts of considerations that we want to think through properly before your children are born. Thank you very much.